Ladies and gentlemen, welcome to Kohler Group's Expansion into China webinar series. This is part 3 of 10 webinar sessions we are doing on helping foreign investors with their market entry, operation, and expansion within the Chinese territory. I am very pleased to have Mr. Gilbert Shen, Senior Associate and Head of Tax at CMS China, presenting on the topic of permanent establishment in China. How does it affect foreign investors? In this webinar, Gilbert will address the general rationale of the assessment of permanent establishment based on normal bilateral double taxation treaties and the PRC tax implications in case a PE is constituted in China. Digests will be made for the PE articles of DTTs based on the interpretations issued by the State Administration of Taxation. The webinar will also cover the general considerations for avoiding a PE in China when a foreign enterprise undertakes business in China. Before we begin today's presentation, however, I just want to go through some administrative issues. If everybody could raise their hand, which is the hand button in the control panel, that will allow me to know that the sound system is functioning. If there are technical difficulties from Gilbert's side or from my side, please don't exit the webinar. We will solve these technical difficulties as soon as possible and continue with the presentation. If you have any technical difficulties, particularly with the sound system, please switch from the mic and speakers on your laptop or desktop to a telephone landline. That will usually help out with any issues that might arise. As is typical with our series, we do like to have an interactive Q&A session at the end of the presentation. I do encourage all attendees to submit their questions and comments into the questions section of the control panel throughout Gilbert's presentation. For those of you that are new to our webinar series or are new to who Kohler Group is, allow me to introduce ourselves. Kohler Group is a CSC company. We provide a wide range of market entry, advisory, and services helping foreign investors going into 3 jurisdictions, primarily Hong Kong, Singapore, and China. We provide a wide range of hand-holding services from advisory to incorporation to all outsourcing solutions thereafter in terms of tax, accounting, and payroll services. We have just over 120 professionals located throughout our 10 offices, and we speak a multitude of languages internally. A little bit about myself. My name is Christina Kohler-Coluccia. I'm a director at Kohler Group. I've been with the firm since 2003 when I first opened our Shanghai office and have been in Shanghai ever since, expanding our operations within the territory. I've been helping foreign investors not only with their market expansion into China, but also with their expansion into the ASEAN region. I'm co-author of our monthly magazine, ChinaInvest.biz. We issue also numerous amounts of publications and resources that are all free of charge and complimentary and can be found on our website. If you're interested in being updated on a weekly basis on these resources and what we produce, then please do subscribe on our homepage by simply inserting your email address. Now, without further ado, I will leave the presentation to Gilbert. Gilbert?
Hi, can you hear me clearly?
Yes, we can.
Okay, sure. Thanks, Christina. And yeah, I'm very honored to speak here to address the topic of the permanent establishment in China. And before we move forward, and I just want to ask one question. Why are more and more foreign investors concerned about whether they have constituted a permanent establishment in China? So actually, the permanent establishment is not a new concept under the tax system. it is a concept introduced by a normal or typical bilateral double taxation treaty between one country and the other. So especially in China, for Chinese cases, if a foreign investor constitute a permanent establishment in China, it means that they need to pay PRC corporate income tax in China. So that's why many foreign investors want to check the conditions for constituting a permanent establishment in China, and they want to check how to avoid a permanent establishment in China. So in today's topic, Christina, next slide. Yeah, in today's topic, I just want to address the following three sections. Okay, the first is the PRC tax implications without a treaty protection. The second is the typical definition and interpretation of a permanent establishment under a bilateral double taxation treaty. And the third part will be the special consideration for cross-border related party service arrangements, which is an anti-tax avoidance topic. So next slide. Yeah. So the first topic, the first section of this topic is the PRC tax implications without treaty protection. So why we want to talk about this? Because as we just mentioned, a permanent establishment is a concept introduced by a typical bilateral double taxation treaty. But before we talk about the bilateral double taxation treaty, we want to have a look at how a domestic PRC corporate income tax law says about the taxation method on a foreign investor. So next slide. Yeah. Under the PRC corporate income tax law, for example, if a foreign enterprise, in this topic we have a very technical terminology here. We say non-PRC tax resident enterprise. So this non-PRC tax resident enterprise normally refers to a foreign enterprise which is incorporated under the laws of foreign jurisdiction, and it does not have effective management in China. So under such a circumstance, these foreign enterprises will be treated as a non-PRC tax resident enterprise. When these non-PRC tax resident enterprise constitute an establishment or place of business in China, and this establishment or place of business is introduced by the PRC.
Gilbert, please hold on. We've lost you.
Corporate income tax law. Okay, when they constitute an establishment or place in China. Okay.
Gilbert, I think
can you hear clearly now?
I can hear you clearly. We lost you for about 5-10 seconds.
Okay. Okay, then shall I go on?
Yes, go on, go on.
Okay. Yeah. So let's continue. We just talked about an EPB under the PRC corporate income tax law. When a foreign enterprise or a non-PRC tax resident enterprise constitutes an EPB in China, according to the PRC corporate income tax law, it needs to pay PRC corporate income tax in China. And this EPB has a very similar definition as the definition of a permanent establishment under bilateral double taxation treaty. If a foreign enterprise which is located in a country which does not have a bilateral double taxation treaty with China, then it needs to look at the definition of EPB under the PRC CIT law. Let's have a look at the definition of EPB under the CIT law. So we have two kinds of EPB. The first kind of EPB is normally a fixed base. It's a fixed, sorry, the previous slide.
Sorry.
Yeah. Yeah. The first type of EPB is a self-operating EPB, which means that it has a fixed base. it has a fixed management office or fixed business office or representative office or some fixed places for labor services or farms or factories or other places for exploitation of natural resources. So this is a very normal EPB, right? Apart from this normal self-operating EPB, next slide. Yeah, we have a second type, it's an agent EPB, which means that the non-resident enterprise authorizes a business agent to engage in production or operation activities in China, including entrusting these agents to sign contracts or store goods or deliver goods on behalf of the foreign enterprise. In such a circumstance, the non-resident enterprise has constituted an EPB in China. From the definition of the EPB above, we can see that the definition in the PRC law does not give a very specific timeline for the activities carried out by a foreign enterprise in China. It means that even if a foreign enterprise dispatches its employee to China to provide service for maybe even one day, it may still constitute an EPB in China to pay CIT in China. But this is the case where we don't have a bilateral double taxation treaty that applies. If an EPB is constituted in China, the non-resident foreign enterprise needs to pay 25% corporate income tax based on a deemed profit rate ranging from 15% to 50% of the revenues attributable to the EPB. Apart from this corporate income tax, they also need to pay, for example, the indirect taxes such as VAT and local surcharges. But this VAT and local surcharges have nothing to do with the EPB, which means that even the company does not, even the foreign enterprise does not constitute an EPB in China, they still need to pay VAT and local surcharges. But for the corporate income tax, only when they constitute an EPB, then they need to pay. Apart from the CIT and VAT and local surcharges, they also need to take into consideration the potential RIT, I mean the individual income tax implications of the individuals who are working for the EPB. So next slide. Yeah. So as we just mentioned, permanent establishment is a concept introduced by a typical bilateral double taxation treaty. After we talk about the EPB as described under the PRC domestic corporate income tax law, let's have a look at the permanent establishment definition under the bilateral double taxation treaty. Yeah. If the foreign enterprise is located in a country where which has signed a bilateral double taxation treaty with China, it should look at the definition of the permanent establishment. It means that unless it constitutes a permanent establishment in China, it does not need to pay CIT in China, even if it constituted an EPB in China according to the domestic PRC CIT law. So I think many countries in this world nowadays have signed a bilateral double taxation treaty with China. For example, the United States or Germany or France or Singapore or some foreign jurisdictions in most European countries and even some countries in Africa and South America. Yeah. So let's have a look at the definition of permanent establishment in the double taxation treaty. The term PE, I mean the permanent establishment, it especially includes a place of management or branch or an office or factory or workshop or mine or oil, gas well or quarry or any other place of extraction of natural resources. Okay, this definition is very similar as the definition of an EPB in the domestic PRC CIT law, right? Next slide. When we talk about such a normal PE with a fixed base in China, we have some exceptions here. For example, if there's the use of a facility solely for the purpose of storage or display of goods or merchandise belonging to the foreign enterprise, or maintenance of a stock of goods or merchandise for the purpose of storage, delivery, and display, or for the purpose of processing by another enterprise, or for the purpose of or a fixed place for the purpose of purchasing the goods or merchandise, and some other fixed places for the purpose of carrying on any other activities with an auxiliary or preparatory character. These kinds of fixed place should not be treated as a permanent establishment. For example, if a foreign enterprise has a warehouse in China, they lease the warehouse in China just for the purpose of storing some goods imported from the foreign enterprise, and they will use these goods imported from the foreign enterprise to sell in China. And such a kind of warehouse, if such a kind of warehouse is only used for the sole purpose of storage and the goods delivery, then this warehouse itself should not be treated as a permanent establishment constituted by the foreign enterprise in China. Okay, so these are the exceptions. So let's have a look at other kinds of permanent establishment in China. Next slide. Okay. The second type of permanent establishment is a construction PE, construction permanent establishment. It means that it means an building site or construction or assembly or installation project or supervisory activities in connection with those building site and construction or installation projects. And such kind of project lasts for more than 6 or 12 months in China, then such kind of project or supervisory activities will be treated as a permanent establishment constituted by the foreign enterprise in China. Here, I have listed out several typical countries which have signed a double taxation treaty with China. For example, under the double taxation treaties between China and the Netherlands, and Germany and France and the UK and Switzerland, the time threshold for constituting a construction PE is 12 months. But for some other DTTs, like the DTT between China and Singapore and the US and Hong Kong, and Australia, they have this prescribed and time threshold. Under such a circumstance, you may have a check whether, for example, if a foreign enterprise dispatches any engineers or some building workers to China to work on a building site or work on an installation project, they need to check whether the time threshold for such a kind of project exceeded the 12 months or the 6 months. If they exceed, then a permanent establishment will be constituted in China, and they need to pay corporate income tax in China. And next slide. Yeah. This is an interpretation issued by the PRC, State Administration of Taxation, regarding the definition of a construction PE. And previously, we talked about the time threshold for constituting a construction PE in China. So how can we count the period to see whether such a kind of period reaches the time threshold? Okay, such a period counts from the date on which the contract entered into is implemented to the ending date on which all projects are concluded and delivered for use. Okay, this is a whole period concept. And for those cases where a general contractor is involved, for counting the period of a general contractor, the entire project period should be counted. And if two or more work tasks of building site or the same project in China are contracted consecutively, the continual period of project operations shall count from the commencement of the first work project to the conclusion of the final work project, instead of counting each work project separately. Let's have an example. For example, if a foreign enterprise dispatches certain employees or workers to China to build a house for a Chinese customer, before building a house, they also have a contract with the Chinese customer to do some piping works. Okay, but piping work is the precondition for moving forward to the to the building work. Okay, so we can say these are two different work tasks, but they are consecutive. They happen consecutively. Okay, the worker needs to do the piping work first, and subsequently they continue with the building work. So these two work tasks should be counted together for the assessment of whether the 6 months or 12 months is reached. And the last interpretation is, if an operation ceases temporarily in the midway due to any reason that have not been withdrawn, the continual period shall count without interruption, and the dates on which the operation ceased shall not be deducted for counting purpose. Let's have an example. For example, if the construction work stops only temporarily for maybe 1 month or 2 months due to the bad weather, or due to the strike of the workers, or due to some other maybe the quality issues of the project. And after these issues disappear, the work will continue after maybe, for example, 1 month or 2 months. Then such an temporary stop in the midway of the project shall not be deducted from the whole period for counting purpose. Okay, next slide. Okay, so then let's have a look at the third type of a permanent establishment, which is the service PE. For a service PE, that means in furnishing of services, including those normal consulting services through an employees or other personnel engaged by a foreign enterprise, continues within China for a period or periods aggregating more than 6 months or 183 days within any 12-month period. So this is a normal service PE. When this service has nothing to do with the construction we talked about. Okay, we just talk about other non-construction services here. When a foreign enterprise has non-construction services in China, we look at the definition of the service PE. I have also listed out several typical countries here which have a double taxation treaty in China, with China. For example, under the DTT between China and the Netherlands and Germany, France and Singapore, and UK and Hong Kong and Switzerland, the time threshold for constituting a service PE is 183 days. But for the US and Australia, which also have a double taxation treaty with China, the time thresholds are 6 months. So next, let's have a look at the interpretation of next slide. Yeah, let's have a look at the interpretations issued by the PRC, State Administration of Taxation, regarding the service PE. Okay, in the definition, we mentioned an employees or other personnel engaged. Here, the employees or other personnel engaged refers to the employees of the enterprise or any individuals employed by the enterprise who provide services in China under the control or instructions of the enterprise. That means this personnel may not be a formal employees, may not be a formal employee who have formal labor contracts with with the foreign enterprise. It can be for example, it can be an independent service provider, but hired by the enterprise. Okay, and the second interpretation is about the same project or related projects. Okay, when we talk about the definition of the service PE, we mentioned that if the time threshold is reached for the same or related projects, a service PE will be constituted. But what is the definition of the same project or related project? We should consider the following factors. The first is whether these projects are contained in the general contracts. For example, a foreign consulting company needs to provide consulting service to a Chinese customer. The consulting service will be provided in two phases. The first phase is giving advice, and the second phase is to help implement the advice. These two work tasks are usually listed in the same contract. And under such a circumstance, of course, these two tasks cannot be separated for assessment purpose. They should be considered as the same or related projects for accounting purpose. And the second interpretation is if those projects are under different contracts, whether those contracts are entered into by the same person or any connected person, whether implementation of a project is necessary conditions for implementation of any latter project. Okay, still go back to my previous example. If the implementation of the advice, should be should follow the first task of giving the advice, and giving the advice is the precondition for the implementation of such kind of advice. Then these two work tasks, even if they are covered under separate contracts, should still be considered as the same or connected projects for accounting purpose. And the third factor is whether those projects are the same in nature. Okay, if two work tasks are all relating to consulting or advisory for the same big project, okay, they will be considered as connected or the same projects for assessment purpose. And also the last factor is whether these projects are implemented by the same personnel. Okay, if we dispatch if a foreign enterprise dispatches China to work on the advisory and also the following implementation, then such implementation and advisory tasks will also be considered as the same or related projects for assessment purpose. Next slide. Next slide. Okay. Then let's move to the definition of aggregate 183 days within any 12-month period. Okay. In the PRC tax regulations, it only interpret the aggregate 183 days of a service PE. It does not give any interpretation on the cases where 6 months are involved. Okay, so let's first let's have a look at how the PRC domestic tax interpretation says about the 183 days. First is, okay, we count the number of months or days during which relevant service personnel stay in China. And the second is overlapping day during which more than one personnel stay in China for the services should be counted as 1 day, which let's have an example. If a service project lasts for maybe maybe several months, but less than 103 days. During 1 month of the service period, the foreign enterprise has dispatched three employees to China for the services, and they have stayed in China for a whole month. In that month, then the total number of days for counting purpose should be 30 or 31, based on the exact number of that relevant month, but should not be 90 days, because these three employees are working on the same project simultaneously. We cannot we should not sum up their total number of PRC days for counting purpose. We only take 30 days of that month for counting purpose. So that's the example of point B here. And point C is in the event that the project continues for several years. If on-site services in China last for more than 103 days within any 12-month period during the whole project period, the enterprise should be deemed to have a PE in China. So it means that this 12-month period is not confined to a calendar year. It is relating to any consecutive 12-month period on a rolling basis. Okay. The point D here is if the non-resident enterprise, okay, it means the foreign enterprise I just talked about. If this non-resident enterprise or foreign enterprise at the time of transferring to the Chinese client the right to use the proprietary technologies and then dispatches personnel to provide relevant support. According to the PRC tax regulations, such kind of supporting service will be treated as part of the royalties for PRC taxation purpose. Okay. Because in this case, the foreign enterprise has already licensed the technology to the Chinese customer. So any supporting services relating to this technology license should be considered as part of the license for PRC tax purpose. And for such kind of license, normally 10% PRC withholding tax should be paid by the foreign enterprise, even without the existence of the PE in China. So, so this is something I think many foreign enterprises should take into consideration when they sign some technology licensing agreement with the PRC customers. The next slide.
Gilbert, I just want to interrupt you because there's a question that came in just now in regards to the definition of the 12-month period. So if you don't mind, that maybe we just focus on that question because it really pertains to this slide. The question is you mentioned that the 12-month period does not follow the calendar year, but does the 12-month period follow the start date of the contract or the day that the personnel are on the ground?
The 12-month period is not relating to the date of the first. I mean, the 12-month period should be counted on a rolling basis. It has nothing to do with the contract date or the first date of the personnel visiting China. But when we count the number of days, I mean the 183 days for the employees working in China, we should count from the first date when the first employee entered into China for the services.
Okay, understood. Okay. We'll move to the next slide. Thank you, Gilbert.
You're welcome. Okay, next slide is about the fourth type of typical permanent establishment. It's an dependent agent PE. And it has a similar definition of an agent EPB under the PRC domestic corporate income tax law. It means that where a person is acting in China on behalf of the foreign enterprise and habitually exercises the right to conclude contracts in the name of the foreign enterprise in China, then the foreign enterprise should be deemed to have a PE in China. And when the activities of an agent in China are devoted wholly or almost wholly on behalf of the non-resident enterprise, such kind of agent will not be considered to have independent status. In other words, it will be considered to have dependent status, right? So let's have a look at the interpretation issued by the PRC domestic tax authorities. An agent without an independent status may either be an individual or an office or company organization in any other form which is not necessarily duly authorized representative of the enterprise or an employee or department of the enterprise. So it has a very broad coverage here. It may not, this agent may be a person, okay, maybe an organization, maybe an office, maybe a company. The second interpretation is about the phrase conclude contracts in the name of the enterprise. It includes the circumstance in which the contract concluded not in the name of the enterprise but is still binding on the enterprise. And this conclude refers to not only the conclusion of contract itself. It can also include the cases where the agent is entitled to participate in contract negotiations or discussing those important clauses of the contracts on behalf of the foreign enterprise. So, okay, when a foreign enterprise says, okay, my agent here does not sign any contract in China on my behalf, it only helped me to he only helps me to negotiate some clauses for the contracts, but the final contract will be signed by me here abroad, not in China. But in such a circumstance, this foreign enterprise should still be deemed to have an dependent agent P in China. The next slide. Oh, sorry, the first 2 points in this slide may be redundant. So let's look at the third point directly in this slide. The third point is the judgment of habitually. Yes. When we read the definition of a dependent agent PE, it says that if this agent has the right and habitually exercises the right to sign contracts in China on behalf of the foreign enterprise. So the definition of how can we understand this habitually? The judgment of this habitually should be made comprehensively based on the nature of the contract, the nature of business of the enterprise, and the frequency of the relevant activities of the agent. Let's have an example here. This example is also described in this slide. For example, this agent helps conclude a contract on behalf of the foreign enterprise only for the sales for the aircrafts, because the aircrafts have a very high value, and maybe this agent only helps the foreign enterprise sign one sales contract with a Chinese customer during 1 year. Still lead to the constitution of a PE in China, because the aircraft is a very high value product, and such a high value will give you a concept that and the foreign enterprise under such a circumstance, the foreign enterprise usually have a very low frequency of signing contracts with the Chinese customers or other customers. So even signing one contract on behalf of the foreign enterprise in China will still lead to the constitution of a PE in China. Next slide. Okay, so let's continue with the interpretation of a dependent agent PE. So any agent whose activities meet the following two conditions should be an independent agent without constituting a PE in China. Okay, the first is the agent is independent legally and financially from the foreign enterprise. And the second is in carrying out these activities on behalf of the foreign enterprise, this agent generally acts in its own ordinary course of its business and does not carry out any activities which are financially attributable to the foreign enterprise. So let's have a look at how we can understand the independent legally and financially from the foreign enterprise. First, we should assess the freedom of the agent to carry out business, whether it carries out the agent business under the command of the foreign enterprise or on its own will. If it's working under command of foreign enterprise, okay, it's a negative point for assessment. And the second point is who assumes the risk of business activities carried out by the agent. Is the agent itself or the foreign enterprise? If it's the foreign enterprise that assumes the risk of the business activities, then still it will be a negative factor for assessment. The third point is the number of enterprises represented by the agent. If this agent works wholly or almost wholly for the foreign enterprise only, then it will be a negative factor for assessment. And the fourth point is the degree of reliance of the non-resident enterprise on professional knowledge of the agent. Normally, if it is an independent agent, it has its own professional knowledge, and the foreign enterprise should rely on the professional knowledge of the agent rather than giving the agent an instruction or command for the agent to follow. If the agent follows the command of the foreign enterprise or rely on the knowledge of the foreign enterprise, then it will be a negative factor for assessment. Next slide. Yeah. So in case if a foreign enterprise believes that it does not constitute a permanent establishment in China, after assessing the conditions we mentioned above, it needs to submit certain documents to the PRC tax authorities to go through the formalities. First, it needs to submit a tax resident certificate of itself. Such a kind of tax resident certificate should be an official certificate issued by the tax authorities in charge of the foreign enterprise. And apart from this tax resident certificate, the foreign enterprise should also submit 2 standard reporting forms to the PRC tax authorities when the PRC tax withholding agent declares taxes for withholding. And besides these 2 documents to be submitted to the PRC tax authorities, the tax authorities may also require the company to, the foreign enterprise to provide some more information or documents to justify the absence of a permanent establishment when they initiate any follow-up administration on the cases. Because nowadays, many the PRC tax regulations have stipulated that enjoying a treaty benefit will not be approved by the PRC tax authorities any longer. It means that as long as the foreign enterprise submits sufficient statutory documents to the PRC tax authorities, it can automatically enjoy the treaty benefit, i.e. without constituting a PE in China and exempt from the PRC CIT. But the tax authorities have the right to initiate any follow-up administration to see whether such kind of documents are reasonable and whether on earth the foreign enterprise has the right to enjoy such treaty benefit. So that's why we see a lot of cases in China that maybe after even half a year or even 1 year after the end of the project in China, they are still chased by the PRC tax authorities to provide more information or documents to justify the absence of the PE, which may happen half a year or a year ago. Next slide.
Gilbert, can I interrupt you, because there are a couple of questions that have just come in pertaining to this slide.
Okay.
How, I mean, the impression that people are getting from your comment saying that you have to submit the tax resident certificate, actually it's the company based in China that is subcontracting the services, whether it's for construction or for services. They are the ones who are submitting the documents, correct? So actually it's the Chinese company that is asking the foreign company to give those documents and to provide the reporting forms.
Yeah. For the tax resident certificate, of course, it should be provided by the foreign enterprise because it's the tax resident certificate issued by the foreign tax authorities, not by the PRC tax authorities. So this tax resident certificate should be provided by the foreign enterprise. And the two standard reporting forms should also be completed and signed by the foreign enterprise.
But it's submitted.
From formality perspectives, the foreign enterprise can discuss with the PRC customer to see whether the PRC customer can submit these documents on behalf of the foreign enterprise to the PRC tax authorities when they declare the tax.
And from your experience, who normally does that? Is it normally the client in China?
Normally PRC. Normally the client in China, because they have the obligation to withhold taxes for the foreign enterprise. And when they withhold the taxes for the foreign enterprise, they need to submit these documents to the PRC tax authorities.
So actually the trigger point for understanding whether you've constituted a PE or not is when the payment of the invoice from the foreign investor is going to be paid by the Chinese company, and the tax authorities will then start asking questions.
Yeah.
So there's no self-assessment.
I think the first step should be the self-assessment, because when you say, okay, we have not constituted an PE in China, then you prepare these two standards reporting forms and prepare the tax resident certificate, and then you submit them to the tax authorities for assessment. If they say no, we don't agree because this, that, and we are not convinced that you have not constituted an PE in China, then you should be taxed in China. But if the foreign enterprise does not provide these documents to the PRC tax authorities, under normal circumstances, the PRC tax authorities will just assume the existence of a PE in China and tax the foreign enterprises directly.
Understood.
So I think the self-assessment is very important beforehand.
Understood. So actually, it's better that the contract is registered before any payments are made. Gilbert, sorry.
I cannot hear you now.
The question was, it's better that the contract between the...
Sorry, I missed your voice for several seconds.
I'm repeating the question. The question is it's better that the contract is then registered before any payments are done with invoices.
Yeah. Yes. Because for the contract record or contract registration purpose, the PRC customer should do it with the tax authorities within 30 days after the conclusion of such kind of contracts, regardless whether a permanent establishment is constituted or not.
Understood.
This is a statutory formality to be undertaken in China.
The other question that's coming along is, you've mentioned that a lot of these agreements are between a foreign investor and the Chinese company. Now, most companies going into China, they're utilizing a holding company to hold their investment in China, and they're trying to formulate all the contracts between these two entities, between the holding and the entity in China. So for this purpose, let's say you have a holding company in Hong Kong, or you have a holding company in Singapore or British Virgin Islands, or wherever the case might be. And these holding companies, as everybody knows, has no management, maybe doesn't even have an office because you can have a virtual office. How does PE come into play when you have these types of constructs?
I think this is an anti-avoidance issue here. It is not directly linked to the PE assessment. This will be the topic in the third section I'm going to talk about in today's presentation. Because when, for example, okay, then let's talk about this.
Do you want me to switch slides? Do you want me to switch slides, Gilbert, or?
Okay, you can switch slides to directly to to this section. Next slide. Yeah. So when a foreign enterprise, for example, charges service fees to a PRC enterprise, apart from the PE issue, we need to take into consideration. Another issue is the anti-avoidance administration. It means that the enterprise, the foreign enterprise providing services to the Chinese customer should convince the PRC tax authorities that real and concrete services are provided, and the service fees charged by the foreign enterprise to the PRC customer are reasonable. Maybe from from transfer pricing perspectives, etc. And how can they justify this related party service charges? So let's look at five factors here. These factors are already mentioned in a typical PRC tax circular. The first point is whether the services are necessary and indispensable. Okay, if it's not necessary, the PRC customer, I mean, in your case, the PRC PRC subsidiaries can do it themselves. If, in such a circumstance, even if the Hong Kong or Singapore holding company provides services to these PRC subsidiaries, there may still be some challenges from the PRC tax authorities on the reasonableness of the service charge. Because without the service provided by the Singapore or Hong Kong holding companies, the PRC subsidiaries can do themselves. And with these services provided by the overseas companies, it seems that the PRC subsidiaries does not get any value-added benefits from these services. Then, under such a circumstance, the service charges may be challenged by the tax authorities as unreasonable. And second is whether whether these service fees are charged for investment-related activities that directly or indirectly benefit shareholders rather than the PRC subsidiaries themselves. For example, in some practical cases I encountered previously, the foreign enterprise, in your case, such as a foreign holding company, provides some internal control services or financial statement consolidation services or group reporting services to the PRC subsidiaries. You can see that in these cases, the beneficiary of the services are the shareholders abroad themselves rather than the PRC subsidiaries, because the group reporting and internal control and the financial statement consolidation are the tasks of the foreign ultimate shareholders rather than the PRC subsidiaries themselves. So charging the service fees relating to the internal control or financial statement consolidation is not reasonable. And the third point is whether the service activities are already overlapped with other activities which are already conducted by the Chinese companies themselves. For example, the PRC subsidiaries need to engage some consulting advisors to help with a bidding process, for example. And they have already engaged a third party to help with the bidding advisory. At the same time, the foreign holding company also provides the bidding advisory service to the Chinese company at the same time. So these two activities are overlapping with each other. Under such a circumstance, the service charges charged by the foreign holding company to the PRC enterprise will also be deemed as unreasonable. The fourth point is whether the Chinese subsidiary received or benefited from the specific services. For example, if the Chinese company is under loss status or it has a very poor operation or business result, under such a circumstance, if an foreign holding company charges service fee to this PRC subsidiary, it needs to provide many evidences to the PRC tax authorities to prove that the PRC subsidiaries actually benefit from the specific services. Because they are in the loss status, how can you convince the tax authorities that they actually benefit from services? If they benefit from services, they should be profitable. They should get very good operation status. But now they are poor, right? So it will become a very big challenge to the foreign enterprises under such a circumstance. The last point is whether the relevant activities already compensated for in other transactions. For example, if the holding company also sells goods to the PRC subsidiaries, and they have taken the service charges into consideration when they pricing the sales price of these goods. And at the same time, they still charge service fees to the PRC subsidiaries. Then it will become a double charging, right? Under such a circumstance, the PRC tax authorities will also deem the service charge as unreasonable. If the service fees are treated by the tax authorities as unreasonable, then the service fees will not be allowed to be deducted from the taxable incomes of the PRC subsidiaries for corporate income tax purpose. So it is another topic different from the PE issue. It is an anti-avoidance topic. It means that if the service fees are unreasonable or not substantiated with concrete services, then the service fee cannot be deducted for CIT purpose by the Chinese company. Then it also means that the Chinese company needs to pay 25% or 15% if it is a high service fee. So that's my answer to your last question, Christina. Your last question is whether these unreasonable service charges have anything to do with the PE issue. I can tell you that they are two separate topics. It has nothing to do with the PE, but it is relating to the anti-avoidance administration. If the service fees are deemed as unreasonable, then no deduction for CIT purpose by the PRC.
And do the tax authorities look at all at the substance issue in the holding company? I mean, if there's no substance in the holding company at all, do they take that into consideration when looking at the PE issues, or is that again more an anti-avoidance issue?
I think it's an anti-avoidance issue because the PE finally results in the taxation on overseas company. But the anti-avoidance administration here relating to the taxation on the PRC company.
Right.
For example, in your case, if the holding company does not have any business substance, how can they provide service to the PRC company?
Correct.
Do they have sufficient capacity or function to provide service? If they don't have such functions or capacity, then the service fee will very likely be challenged by the tax authorities as unreasonable. Right. Then no deduction for that purpose.
Understood. Gilbert, I think that's the end of your presentation. There's one more question before we end today's webinar, and it's related to your the slides associated to the dependent agent.
Yeah.
So we have one attendee who's asking or saying they are a company in the UK. They've established a subsidiary in China. In reality, this subsidiary is their sales agent for the Chinese market, meaning that the UK company is the 100% is the one client they have in terms of purchasing and importing goods. Does this mean that not only does the subsidiary have to pay normal profits tax and dividends tax when repatriating back to the UK, but even on any service invoices or commissions that the UK wants to earn, there's then PE on that as well? PE tax on that, or CIT tax on that?
I want to know the business model in more detail for this case, because you mentioned that the PRC subsidiary works as an sales agent for the UK company. So does this mean that the PRC sales agent charges commission fee to the UK as its own revenue?
Yes, it does.
Yeah. If so, I don't think the PE risk is large here, because the tax authorities will levy the corporate income tax on the sales agent as an independent legal entity in China.
Understood.
So under such circumstances, I don't think that the UK company has a large risks regarding an dependent agent PE in China.
Okay. Well, Gilbert, that's all the questions that have come in. I want to thank you for your time and for presenting to all the attendees today. Thank you very much.
My pleasure.
For all of the attendees, if you have any further questions or you want to speak with Gilbert directly, his contact information is on the presentation that will be distributed to you, so don't hesitate to contact him. If you would like me to make a formal introduction, I would be more than happy to. Don't hesitate to email me, and I can make a further introduction to Gilbert as well. Just some last-minute administrations. We have another 7 webinars in this series that are occurring. If you've been enjoying the webinars in the last 3 days, please do register for the upcoming 7. We'd be happy to see you there. And last but not least, if you are interested in subscribing to our resources, our magazines, our webinars, future webinars, then please do so on our homepage. Gilbert, again, thank you very much for joining us. And to the rest of the attendees, I wish you a very pleasant day.
Thank you. Thank you.
Thank you, and goodbye.